That suits me. Set it up.
So I guess I'll try to contact Steve Etcher again and see if he can
Right.
get that checkbook to us, and then you and Rick can sign over the balance of that account over to the treasurer so we can get that done. That's all I have.
David?
I would like to ask Matt Bass to make a motion for our credit card policy and a timeline and have it voted on so it's reflected correctly in the minutes. So, you know, we were 7 months into this, and I understand, and I'll take whatever timeline you guys see, but at least then it will be correctly stated in the minutes. I belong to a few other clubs, and I will say we hold parliamentary procedure very dear to make sure people are held accountable and it's reflected in the minutes. So I would like to ask Matt.
Yeah, that's very interesting, because I was sitting here thinking the whole time that we probably wanted to do that. I'd like to back up a little bit to to last week when we were discussing opening the budget. There was a lot of discussion that day. I don't think we was ready to make a motion that particular day about how to go about that exactly. The discussion was about Oates money, the discussion was about police money, whatever, I forget what it's called exactly, but the drug seizure money, all that. That's what we talked about, all that kind of stuff, we did. But we also even talked about to that extreme when you open the budget, would you open the budget even with a $500 insurance check? It was very unclear because there wasn't much common sense put to it all at that particular time. I don't think. Yes, we did talk about it, doing it with that, but then we ended up not doing it because I don't think we was ready. You know, and yeah, David, I'm ready all the way to make a motion to that.
Well, if you would make one today, so then the people here, and it'll be reflected in the minutes, and the commissioners can vote on it. Obviously, if they vote it down, it doesn't matter. But
I mean, what kind of timeline would we want to put on it? Month, couple weeks, you know, it depends how long it's going to take to.
well, you guys are the commissioners. We're not trying to put on.
30 days.
Well, all right, I'll make a motion that we'll have that in 30 days. Because I believe we need it, and I believe we're going to have it. I believe we talked about it before, and we got caught up on snags, and then we didn't do it. So I will make that motion.
I feel certain we were gonna have it whether we have a motion or not, but I see no problem with the motion. Second.
Got a motion and a second. Any further discussion? All in favor of having a credit card policy draft in place in 30 days, signify by saying aye.
Aye.
Aye, the ayes have it.
Thank you.
Thank you. John, do you have a question?
Okay, back to the budget. I might add, continuing to kind of plead my case on this, that it is a normal procedure. Probably most counties don't open the budget just for a $500 item. But for anything, you know, and I don't know where you draw the line of what you consider a significant amount, but anything that wasn't specifically anticipated in January, you know, and that would be aside from your normal revenue that you know, your normal tax revenue, you anticipated that in January, you may over-anticipate or under-anticipate. Whether you end up getting more or less, you don't open the budget to change that. You open the budget only for new, unanticipated revenue that you actually have coming in, such as the equitable sharing funds and such as the grants. Platte County has already opened their budget twice this year. We have a new auditor. Asked him if they have to go through the whole thing of putting it in the paper and having the hearing, and he said yes they do. But he said, you know, it's pretty easy actually, and he's still a rookie. Callaway County, because I quoted that this is outlined under revised Missouri statute 50.622. Rosemary Danaway says you have the correct statute to quote. If the commissioners can't read it and understand that, don't know what else you can do to convince them that it's legal and right to make those amendments. Boone County, June Pitchford says, I agree with both responses you've received. The only other thing I have to offer is that auditor certification of expenditures is required in order for invoices to be approved by the commission and dispersed by the treasurer. Your certification expressly states that there is sufficient appropriation available to cover the expenditure and sufficient cash in the fund to which it is charged. If the commission won't amend the budget, then you can't certify spending beyond the available and remaining budget amount. She says you might try using the public disclosure and transparency argument. The reason for the budget amendment statute is to ensure a publicly accessible and transparent process by which public monies are budgeted for spending. Jasper County, Richard Webster. I concur with both June and Rosemary. You can't force the commission to amend the budget, and having experience in doing amendments, it is time consuming and a pain, but you can only certify for payment what remains in the budget, what was appropriated, and what is available, how much is in the bank. You cannot go over budget. If you reach the budget maximum, you can no longer certify expenditures for payment, and they will have to amend it or shut down the government. You might remind them of that. Rick Finley, Taney County. Deanna, I believe you have budgeted I believe if you have budgeted some contingency so that your expenses are not more than appropriated, you can allow that expenditure. If you do not have appropriations in the original budget to allow for expense, then you will need to revise the budget. So those are replies I've gotten from other auditors. It was, no, I didn't get replies from all 20, but all 20 were there at my training when this was discussed, and looked to me like they all do it. Nobody said, oh, this is such a crazy thing. You open your budget, and it was a normal procedure.
I have a copy of what Mr. Webster, I believe, from Jasper County sent. You can only certify for payment what remains in the, and this is echoing the decision that Judge Mobley made in 2009. You can only certify for payment what remains in the budget, what is appropriated, and what is available, how much is in the bank. Is anybody at 95% of their budget, or even 80% of their budget, bottom line appropriation? We're not disputing the fact that at some point we're going to have to open up the budget. But I'm going to quote him again, it is time consuming and a pain. We will bunch our transactions together and we will amend it.
And I think the amendments, though, that he's talking about it being time consuming and a pain are the adjustments that have to be done after you put things to the different budget than what he's talking about the accounting entries to fix everything on the back end. He's not, the amendment to the budget really is not, the way our accounting system is set up, it's an easy process. You put together a packet, a budget packet with the lines you need to add and the amounts you need to change, and once it goes through the hearing and it's approved, you just post that packet in and it changes the budget. It's not a diligent process in the accounting system.
But everyone is within their appropriation. We have money in the bank. Everyone's operating within their budget. And if there comes a time when, we know that Mike's situation where he's going to get up against the budget, and then we're going to have to go back in, and we're going to have to honor the appropriation. We know that. But right now, Mike is working feverishly to work within the confines of the budget. John?
Yes. In 2009, when the judge issued that order, were we a Class 2 or a Class 3 county?
We were a Class 3 county.
Okay, so now we have an auditor in the equation. So would that change in classification of county possibly change the judge's ruling in that matter? Not at all? Mm-hmm.
No. We could spend another $20,000 to find out.
Mm-hmm.
David?
This goes way back to your discussion earlier, and I think I know the answer, but and I do understand to save money. You had said that, and I know there, and I won't say contentious between the commission and the auditor, but we all realize that you know, some of the thoughts of the auditor relative to the commission and other elected officials, nobody in particular. You know, if you have 3 lawyers, yours, the private, and the MAC, and doesn't agree with hers, I mean, I don't think anybody out here, and, you know, we're not for throwing money away, but, you know, we want closure. You know, nobody wants to be mired down in this. So if you've got a 3-to-1 lawyer advantage, and I'm not trying to be facetious here, is, you know, maybe we have to go that extra, whether it's the commission against the auditor or the auditor against the commission. I'm not suggesting pitting them against each other,
Right.
but we're trying to say is nobody wants more people to have to come in here and we have to keep listening to things and listen to open the budget or not open the budget and things like that. And we all know that state statute is murky at best. And then you take in how many years ago it was wrote relative to time and stuff like that. But, you know, maybe and an arbitrator of some sorts, you know, instead of spending $20,000 to take it to court and find out,
Right.
the commission would, and I think the people, and you know, there would be a great idea for the commission. What do the people think? Well, let's put 4 lawyers, let's put an odd number of lawyers in the room so we get a decision and say, hey, this is where we're at. And we have, how many other Class 2 counties in Missouri? I don't know. How many other Class 2?
3 maybe.
I mean, you know, can we look at them for some guidelines? We can't be breaking.
Here's, yesterday we discussed trying to go through and do something real similar to this, to go to the Attorney General.
But the Attorney General won't give a written opinion.
Actually, they will. Actually, they will, but here's the problem. The auditor's made it very clear that she's, you know, I very openly said, hey, if the Attorney General comes back and gives an opinion and says, Commissioner Colbert, you're wrong, I'll say, hey, I was wrong, and step exactly away from it.
And I'm sure the auditor would do the same thing.
No. She's expressed yesterday
If the Attorney General tells her she's wrong, she's not going to abide by that?
that was the impression I
I
got.
believe we'll have to.
Well, it's not binding. What is the next step, and, you know, the more and more I talk about this, the more times I talk to counsel, the consensus among counsel is the Attorney General's opinion isn't binding. You have to get a declaratory judgment. And unfortunately, you know, where do we quit involving lawyers? Do I have to get 5 lawyers to give my opinion to make her believe? Do I allow John Q. Public to bring his lawyer in off the street to give the dissenting opinion? I'm paying big bucks to get legal advice from people who are in the profession, but
if we're paying big bucks for the thing, then wouldn't it make sense to, and as much as I hate to go to court or do something like that, I mean, we're spending the money anyway for all this advice,
Right.
and we're spinning our wheels. Do I want to see us bogged down in legal action? No, you know, and it goes back to the thing, if she has legal counsel and the county has legal counsel, we agree on an arbitrator, whether it be the Attorney General or something, and both have the same amount to lose. I mean, to me, I see it as a win for the taxpayers of the county, because we finally get closure, no more meetings discussing this stuff, and says, hey, you're agreeing, this side's agreeing that you're going to abide by the arbitrator, you're abiding by the arbitrator, and if we can't agree on an arbitrator, then let's just take it to court and be done with it, because we're just losing money, losing time. And the people that are in this room, this is my belief. Everybody wants to see this county, you know, we got St. Charles County growing tremendously next to us. Lincoln County has its problems, but we all live here. We have our reasons that we want to live here. And we want to get this closure so we can attract the retailers, the business, the stuff like this. We don't want to be known as the ones that are always in court or always at an arbitrator, or that our elected officials are always at odds with each other even when they're in the same party.
right.
That's all fine.
Yeah, and that's the juncture we're at, because, you know, we're kind of working on, or, you know, Elaine Hagemeyer and the prosecutor are going to work on putting together, because we want to frame a question to the Attorney General and get an opinion, but the opinion is not binding.
But I would have to believe that the attorney, you know, everybody involved, Leah, the other lawyer, I mean, the only thing I've seen from the little bit of stuff I've had to do with the state is trying to get a written opinion out of them is usually difficult, especially on something that's
A
questionable.
county attorney can get one.
Okay.
They can get easier than if you call in